Keir Starmer insists that we have free speech in the UK, that we've had it for a long time, that we're proud of it, and that we will have it for a long time. And yet today we have reports that Graham Linehan, founder of Father Ted, was arrested by 5 armed police officers in respect of posts that he's made on X. Now, he's a known trans activist, as in he speaks his mind. He has a philosophical belief, which is now protected in law, about those things. You may or may not agree with his views, and you may or may not agree with what he posts. You may conclude that what he posted was wrong, but that flies in the face of free speech. Now, we can't very well have both at the same time. So I'm going to come back to his tweet in just a moment. And by the way, if you do value free speech and you want somebody to speak out and defend free speech, as a barrister of England and Wales, I will commit to that to you if you subscribe to this channel here as an alternative to the mainstream media, who recently have made it abundantly clear that they will not stand on the side of free speech. Please do subscribe. Thank you so much. But I'm just going to remind you of what Keir Starmer said in the Oval Office to Donald Trump and JD Vance when the subject of free speech came up, because it was the subject matter here and challenged by JD Vance as to the issues that they have with the UK when it comes to free speech. So with all this in mind, have another listen to this.
I said what I said, which is that we do have, of course, a special relationship with our friends in the UK and also with some of our European allies, but we also know that there have been infringements on free speech that actually affect not just the British. Of course, what the British do in their own country is up to them, but also affect American technology companies and by extension American citizens. So that is something that we'll talk about today at lunch.
We've had free speech for a very, very long time in the United Kingdom, and it will last for a very, very long time. Well, no, I mean, certainly we wouldn't want to reach across US citizens, and we don't, and that's absolutely right. But
so he says, we've had it for a long time, we will have it for a long time, we're proud of it, and they wouldn't want to reach across US systems. But that is exactly what's happened here, because one of the bail conditions for Graham Linehan is that he's not to go on X and post anything on X. So let's take a closer look at exactly what it was. Now, Free Speech Union, if you're not a member of Free Speech Union, this is not a sponsored video, certainly not by Free Speech Union. They've not asked me to do this. They probably don't know I'm doing this. They probably won't notice I'm doing this. But if you value free speech, I suggest that you join Free Speech Union, because you may need their help someday if you happen to post what you think online. So let's take a look at this. His alleged crime are 3 gender-critical tweets. Now, just to spell this out, gender-critical tweets are apparently those where you speak your view that you do not believe that a man can become a woman or a woman can become a man. That is, in law, that is now a philosophically fundamental protected belief. If you fundamentally and philosophically believe that a man cannot become a woman and they remain a biological man, that is your belief. You are entitled to hold that belief. You are entitled to express that belief. And within reason, you are entitled to manifest that belief. Now, the manifestation obviously has legal limits. You can't just go around beating people up because you disagree with what they are doing, but you can express your beliefs so long as you're not entering to a course of conduct that amounts to harassment or inciting serious violence and things of that nature. But speaking very generally, not about Graham's tweets specifically here, because whilst it wouldn't be contempt of court, but nonetheless, I'll make my comments generally anyway. Generally speaking, if you make comments like this and they are intended to be funny, light-hearted, even provocative, or even annoying, that is not an offence. It is not an offence, contrary to what the police have previously said. It is not an offence to be offensive. You can make offensive comments and abusive comments and annoying comments. You can criticise, you can ridicule. The law does not, well, at least it shouldn't, restrict that. And yet we have police arresting people accused of this. So Graham comments on his Substack here, quoted by Free Speech Union. He says, in a country where paedophiles escape sentencing, where knife crime is out of control, where women are assaulted and harassed every time they gather to speak, the state has mobilized 5 armed officers to arrest a comedy writer. Now, let's go to the Substack here, because there is a quote of some of these tweets further in here. But the bit in highlight, first of all, he said he stepped off the plane at Heathrow and 5 armed officers were waiting. Not 1, not 2, 5. 5 armed officers to arrest a comedian for posts on X. He said they escorted me to a private area and told me that I was under arrest for 3 tweets. One of the allegedly offending tweets is as follows. He says, if a trans-identified male is in a female-only space, he's committing a violent abusive act. Make a scene, call the cops, and if all else fails, punch him in the balls. Now, you might find that offensive. You might disapprove of that. That's entirely a matter for you. But is it wrong in law? Well, I'm not going to comment specifically, just to be on the safe side because he's been arrested for it. But speaking very generally, one is entitled, at least the law says, that you are entitled to express your beliefs without fear of prosecution. Because unless your comments cross a criminal threshold, which should really be a high threshold, especially in a country where the Prime Minister himself says in the Oval Office that we have free speech in the UK.
We've had free speech for a very, very long time in the United Kingdom.
We're proud of it. We defend it. One might even argue as a defence that the Prime Minister said in the Oval Office in defence of the UK that we have free speech. Therefore, it felt that these comments were appropriate because you can say what you think and express your beliefs, even if said posts are abusive. And there is settled law on this, in this case of Scotto and the CPS. There are a number of cases. This is one I often refer to. It's paragraph 43, although I think my big head is covering the paragraph number. If I scroll down, you can see it there, paragraph 43. This is where the court said, this is an unstructured approach that lacks the appropriate rigour. The Crown evidently did not appreciate the need to justify the prosecution, but saw it as the defendant's task to press the free speech argument. The prosecution argument failed entirely to acknowledge the well-established proposition that free speech encompasses the right to offend and indeed to abuse another. The judge in the original case appeared to have considered that the criminal conviction was merited for acts of unkindness and calling others names, and that such acts could only be justified if they made a contribution to a proper debate. Neither prosecution nor judge considered whether some more demanding interpretation of Section 127, that's the malicious communications offence, or addressed the question of what legitimate aim was pursued, or, more importantly, whether the conviction of this defendant on these facts was necessary, whether its proportionate means of responding to some pressing social need. Even when talking about the need for the prosecution, the court said as follows at paragraph 46, I would accept that the stated aim of the prosecution, namely the protection of Miss Hayden from persistent and unacceptable offence, is a legitimate aim. It falls within the scope of protection of the rights of others, which may be but do not have to be convention rights. I do not consider, however, that a prosecution in respect of the 2019 messages could be justified as necessary in a democratic society. And even talking about the general scope of harassment, the court said here, there is a great deal of jurisprudence on the question of harassment, and in particular the tort of harassment by publication. And then quotes the following here. The behaviour said to amount to harassment must reach a level of seriousness passing beyond irritations, annoyances, even a measure of upset that arise occasionally in everybody's day-to-day dealings with other people. The conduct must cross the boundary between that which is unattractive, even unreasonable, and conduct which is oppressive and unacceptable. There is a difference between the two. It can be unattractive, it can be unreasonable, but unless it crosses that threshold to be oppressive and unacceptable, which is a high threshold, then it doesn't cross the criminal threshold. It goes on to cross the border from the regrettable to the objectionable. The gravity of the misconduct must be of an order which would sustain criminal liability. And then to one of the clearest phrases yet with regard to Article 10 freedom of expression rights, the court says, in most cases of alleged harassment by speech, there is fundamental tension. Section 7.2 of the Protection from Harassment Act provides that harassment includes alarming the person or causing the person distress. This is what a lot of police are jumping up and down with respect about up and down the country at the moment. But the court said here, in crystal clear language, Article 10 expressly protects speech that offends, shocks, and disturbs. Freedom only to speak inoffensively is not worth having. So if you apply this test to posts that you read online, if you find them offensive, shocking, disturbing, and even unattractive and unreasonable, they are not an offence to publish such comments, at least in law. We have police arresting people for things that we may believe don't cross this criminal threshold, as I've just described, but here we are. So I put it to Keir Starmer and anyone else in power, do we have free speech in the UK or not? The law is clear. I am a barrister in England and Wales. I am intimately familiar with the law in this area, and the vast majority of things that I read online, even if you find them unattractive, unreasonable, shocking, disturbing, these are not things to be running to the police about. And the police, with great respect, should not be sending the cavalry after it. So let me know what you think in the comments below. We really are in what feels like a police state at the moment, and I put it to those in power to do something about it. Thank you for watching. Please do subscribe to the channel, and I'll see you next time.